Thank you. Greetings, everybody from Uganda, the Pearl of Africa. I'll be talking about the different alternative dispute resolution mechanisms in the resolution of construction disputes in East Africa. Alternative dispute resolution, normally called ADR, refers to different means of resolving a dispute other than reverting to litigation in the courts of law. The construction industry is well known to have many disputes. A construction dispute arises where one party to a contract puts up a claim, either for extension of time, additional costs, or other entitlement, and is disputed by the other, either on the facts or on the quantum. Traditionally, parties would litigate this in the courts of law, but over time, ADR has become the preferred means of resolving disputes because of its advantages. Number one, ADR is swift, it is less costly, it maintains the relationships of the parties, it's confidential, and parties generally have control over the process. Construction contracts will usually have a dispute resolution clause, which is a very important aspect of the contract. And the resolution clause will usually specify the mechanism that will be resorted to in case of a dispute. Now, where there is a clause specifying a mechanism, parties are bound to follow that mechanism in the absence of consent by both parties to follow a different mechanism. I'll run through the different options that are available to the parties. Number one, we have negotiation. Parties themselves attempt to settle their dispute using a range of techniques, ranging from either concession, compromise, confrontation, or even coercion. The key thing about negotiation is that parties have autonomy over the process and the outcome, and negotiation can continue alongside other dispute resolution mechanisms. Then we have conciliation. It is similar to negotiation, but it is usually provided by law. For example, in Uganda, we have it provided by domestic legislation. A third party conciliator mediates the dispute and proposes a solution to the parties. Then we also have mediation, which involves a third party neutral mediator who also helps the parties to reach a mutually agreeable solution. The difference between mediation and conciliation is that in mediation, the parties have control over their solution, but in conciliation, the conciliator proposes different options as solutions. We also have expert determinations. This is where an independent third party who must be impartial acts as an expert in the field to settle the dispute. It is usually used for disputes of a technical nature, where the issue at hand is one of fact rather than law. It's particularly useful where the dispute turns on a point which is of a technical nature. Then parties can also employ what we call early neutral evaluation, where a neutral third party, usually a legally qualified person like an attorney, gives an opinion on the likely outcome at the trial as a basis for settlement discussions. The aim is to test the strength of the legal points in the case, and it is particularly useful where the dispute turns on a point of law. So expert determination is useful in matters of a technical nature, and early neutral evaluation is useful where the matter turns on a point of law. Then we have two other and the most important and commonly used methods of dispute resolution. Number one, we have adjudication before the DAB, the District Dispute Adjudication Board. Disputes are resolved by a third party, what we call an adjudicator, chosen by the parties under the contract, or this person may be appointed by an appointing authority. It is an informal process operating under strict timescales. In fact, a number of commonly used standard forms of contracts, like the FIDIC forms of contracts, usually contain adjudication clauses requiring adjudication as the first stage in the mechanism of dispute resolution prior to commencement of any arbitration proceedings or litigation in the courts of law. Municipal laws of East African states have adjudication proceedings regulated under their domestic legal regimes in form of adjudication guidelines by institutions undertaking adjudication in construction disputes. For example, in Uganda, we have the adjudication guidelines issued by Uganda Institute of Professional Engineers, and Kenya also has adjudication proceedings which rely on the construction adjudication rules issued by the Chartered Institute of Adjudicators. Construction adjudicators are usually professionals from the construction industry, knowledgeable and experienced construction experts, and well-versed in the dispute resolution procedures. The proceedings are not like in ordinary litigation. There's no cross-examination, no formal evidence or lengthy legal arguments, and sometimes facts may be proved solely by documentary evidence. Once both sides have set out their sides of the dispute, the adjudicator helps them to reach a solution, and this must be usually within 28 days or a lesser time provided under the contract. Adjudication decisions are binding, but they can be revised through arbitration or court process. So adjudication does not finally determine the dispute, though in practice, adjudication decisions are usually accepted by the parties. Then the last method of dispute resolution other than litigation is arbitration. It is a non-judicial process for settlement of disputes where an independent, neutral third party, an arbitrator, makes a decision that is binding on the parties. The decision is called an arbitral award, as we all know. The arbitral award, the key thing about it is that it is enforceable in the courts of law like a court decree. So it has a force of an ordinary court judgment. States have legal regimes on both domestic and international commercial arbitration. There's also a regional mechanism at the East African Court of Justice, but we have to note that the East African Court of Justice only has jurisdiction over residents of the East African community. Once an arbitral award has been made, it is recognized and enforced at the domestic level of an individual state where enforcement is sought. An award must be registered and together with the arbitration agreement. An arbitration agreement can either be a clause in a contract or a separate agreement. I will not say much about the New York Convention, which has already been talked about. Most of the East African states are parties to the New York Convention. We have Burundi, Kenya, Uganda, and Rwanda. So an award holder can enforce the arbitral award in the 149 state parties to the New York Convention, and the reverse is true. Someone holding an award from any of the 149 state parties to the New York Convention can enforce their award in any of the East African state parties to the convention. Tanzania, on the other hand, is not a state party, but Tanzania has not ratified this convention, the New York Convention, but its domestic legal framework on arbitration is based on the UN CITRO model, which takes into account the particular features and needs of international commercial arbitration. Thank you.